Hello and welcome to this week in Polity and Governance. We have 5 topics that we are going to deal in detail over a period of next 1 hour. Let's start with the first topic, which talks about the constitutional morality. And as you can see in the heading, it is written a guide to the law, constitutional morality. And the context over here is that now we are completing this year 75 years of the promulgation of the Constitution of India, 1950 to 2025. And so in recent times, our constitutional courts, Supreme Court, have embraced the concept of constitutional morality as a tool to interpret and as a test to adjudicate upon the constitutional validity of statutes. Now the problem is that while constitutional morality is increasingly becoming important, there is an absence on this idea, there is an absence of content on this idea when we talk about basic books like NCERT, Lakshmikant and various other aspects. We teach this in foundation classes as well as in QIP, but when we look at the audience, they are not aware generally of this particular term. Now, if you look at the UPSC Mains 2021, there was a question, constitutional morality is rooted in the Constitution itself and is founded on its essential facets. Explain the doctrine of constitutional morality with the help of relevant judicial pronouncements. So you can see that this concept has already been tested once in the mains examination. At the same time, if you look at the syllabus and if you're wondering to which line of the syllabus you are going to map it into, Indian Constitution, significant provisions of the Indian Constitution is a part of your syllabus in GS paper 2. Now, after having gone through the Bare Act, you must be wondering, I did not come across any such provision in the Constitution of India. Well, you're right. There is no direct reference to the constitutional morality as a term, but there are references to morality. For example, in Article 19, Clause 2, in Article 25 and 26, when we talk about freedom and freedom of religion, there are references, but it's much wider than the reference. It is so prominent that the ex-Chief Justice of our country has recognized constitutional morality as the basic structure 2.0. So you can see that the level that the basic structure doctrine, by the way, which is not explicitly mentioned in the Constitution, gets, the constitutional morality is getting almost the same status. And the more Constitution and polity that you read, more you marvel at the intellect of one man, Ambedkar. Because this is a screenshot from the newspaper of 9th June 1948, where almost the finalization of Constitution was done, and people had a big level of clarity as to what the provision of the Constitution is going to look. So now there was to be very minor changes here and there, but largely the provisions of the Constitution were sealed by this time. And the constitutional provisions were sealed, and so the intelligentsia, elite section, even the people who were aware about what's going on in the Constituent Assembly, they were in euphoria. They were in euphoria because now they felt that we are creating a very revolutionary constitution. So India did not go through a revolution. So India did not have the opportunity to rewrite a new order in terms of politics, in terms of society, which, for example, China had the opportunity because it went through a revolution to establish a new order. India basically went through a transfer of power. And so the writing of the Constitution was taken as an effort to induce revolution in the society through the Constitution. But it was Ambedkar who was aware of that this is still not sufficient. And that's when he highlights that if a jurisdiction and society, people are not moved by constitutional morality, the Constitution is less likely to survive. And that's when he makes this profound speech, you can see, which keeps on coming back in news through Supreme Court judgments and Supreme Court citation of probably the same speech. Before we can understand constitutional morality, let me set the ground, which will make it extremely easy for you to appreciate what this idea is all about. I cannot directly jumpstart at constitutional morality. First, let's understand that in a post-colonial society which has just gotten independence, writing of a constitution is probably the first manifestation of sovereignty. When you create a sovereign constituent assembly which is not bound by any convention, which is not restricted by any pre-existing superior authority, so that itself is a very profound moment in a society when you sit down and you say that whatever we feel like we will provide for all of us. And India did a decent job in codifying a constitution. So the Constitution of India was codified, which means the entire constitution could be found at one place, the codified constitution. And we did a pretty decent job in finalizing the provisions of the constitution. So we laid down the government setup, we laid down the institutions or organs of the state. We just did not lay down the organs of the state. We also kind of provided very, very specifically their functions, their responsibilities, and as well as we laid down the power of these institutions. At the same time, the constitution also talks about the relationship between the state as well as the individual. And the way we did that in 1950 is that every individual will have rights against the state. So this was the way through which we determine the relationship between the state and individual. To begin with, in a very shallow way I'm talking about, because this is not the main topic of discussion. At the same time, this cannot be the purpose of writing down the constitution. So the purpose of writing down the constitution should ideally be to create a limited state, or the idea of constitutionalism. And so if you look at the provision of the Constitution of India appears very good on the scale of constitutionalism. So we also did a pretty decent job in providing a constitutional government or constitutionalism. We have created a limited state. So we have created a limited state by, separating the powers. So we have followed the separation of power. Same people who make laws will not enforce the laws. Same men who may enforce laws will not adjudicate upon the laws. At the same time, we have vertically fragmented the power between the center and the state government in form of federalism. So that is a limitation. Neither the central government nor the state government are all powerful. Their jurisdictions are limited by each other. So that is a federal structure. Then we have provided fundamental rights, which essentially, if you look, acts as a restriction on the state. So that is a limited state that we have created. We have created a bicameral legislature. So power is fragmented at the central level. So bicameralism, in essence, is again a sort of a creation of a limited state. Why people were happy, especially the participant of the Constituent Assembly, that our task is done now. Now we don't have to worry about anything, because we have codified the Constitution and we have provided a very rigid procedure to amend this Constitution, and at the same time we have provided a constitutional government. But it was Ambedkar who understood exactly the limits of codified Constitution. And towards the end of finalization of the text, which was his own project, he was the head of the drafting committee, while there were other committees to actually research on various provisions of the Constitution. It was ultimately the responsibility of the drafting committee to finalize the final text. All of us know that. And the same person now becomes extremely skeptical, doubtful about the future of the Constitution. Because when he did research on various political systems available across the country, when he was finalizing, when he was involved into the pursuit of finding out the best solution for the political structure, how to transform the society, he was moved by one thing. And that one thing is the tendency of the constitutions across the globe to fail. Almost every constitution starts with some radical ideas, starts with good values, but not every constitution survives. And so he was moved by, he was intrigued by, he was curious to know as to what is it that eventually fails the constitution. Why do constitutions not survive beyond 1 or 2 decades? And that's when he understood that just having written down a codified constitution which provides for a constitutional government is not sufficient. Why do codified constitutions fail? There are ample number of reasons as to why the codified constitutions would fail. For just as a starter, you can see that codified constitutions provide a mechanism for their own amendment. But amendment process generally is extremely difficult. And this is done so that the day-to-day majority, the transient temporary majority of the government should not be able to tweak with the fundamental supreme law of the land. But it makes the process of amendment extremely rigid. And because the process of amendment becomes rigid, it takes a lot of time for the constitution to respond to the changes in the society. So the response becomes extremely slow process. So response is generally delayed. That was one reason. Because the response is delayed, it is not able to match the pace of the change. People can become frustrated. For example, Women Reservation Bill took 25 years to be implemented, 106th Constitutional Amendment 2024. It took around 20 years for the country to build consensus on one nation, one indirect tax in form of goods and services tax, GST, brought in 2016. But the discussion on idea began in somewhere around 1999 to 2001. And since then, every government tried but failed because no government had the majority, and at the same time, the consensus was difficult to build. So you can see the response of the codified constitution is generally lagging. That is number one reason which can create strains in the society. Number two is that a fundamental problem that the codified constitutions have faced across the globe is that when you are about to finalize one text which will become the supreme law of the land, you will have to make difficult choices. So for example, when it comes to the form of the government, you can go for either presidential or parliamentary form of government. When it comes to voting, you can either go for first past the post, or you can go for one of the various options available in proportional representation system. When it comes to relationship between state and individual, you can define that relationship in terms of rights against the state, or you could also define it duties towards the state, but you'll have to choose one. India chose rights framework. That's why it is a liberal democracy, because it prioritized liberty. And so the fundamental problem is that you will have to choose one, and as soon as you choose one, the others are relegated to a very inferior position. They are pushed towards the corner, and that's when creates disgruntlement in the society, because you have chosen one. And so you can see that all the constitutions, especially the codified ones, are inevitably a biased document. And biased documents can create disgruntlement in the society. Also, the third problem that he could see at that point of time as well with respect to codified constitution is that, especially if the codified constitution contains radically different values, which in some cases might go against the morality of the society, that's when you have the biggest problem. Now, when you are writing the constitution, you are providing justice, but the society has been committing injustice. You are providing for equality, but Indian society has made rules in form of caste system of inequality. You are providing fraternity, you are aspiring to create brotherhood, but the society does not believe in brotherhood. Society does not believe in fraternity. In fact, the social institutions fragment the fraternity. And that's when he understood that why constitutions do not survive. Because the social morality, the common understanding of what is right or what is wrong, has a lot of stickiness. It is more resilient because people have followed the social norms for hundreds of years, if not thousands. And so these social values have remained a part and parcel of people's thought process. So the social outlook of every person is being determined by the social morality, whereas you want the people to be moved by the constitutional morality. That's when the constitution will survive. And so, slowly and gradually, you will have to make people aware about the values of the constitution. So, why the constitution failed? The constitution failed because of the resilience. Because of the resilience of social norms which can go against, and you can see it did go against the social norms in case of India. Now, then what is constitutional morality? And why did he make this speech? He made this speech just to highlight this point that if we will not train people to follow the norms of the constitution, and he laid down 3 exact principles which will not be followed. If they will not be followed, then creating the most beautiful constitution with good provisions will have no meaning, will have no effect, and the constitution will fail. Now you can understand why this term has come into news, because now we are celebrating 75 years of the survival of the constitution. So there must be an element of constitutional morality. What Ambedkar had to say about the survival of the constitution in form of constitutional morality? The first and foremost principle that he understood that will allow the constitution to survive, that if people will follow that, they will have we will have constitution perpetuating into the eternity, to lasting future. Number one is that people should have utmost respect, reverence to the values of the constitution. Number one, because if people will not have reverence, if people will not have respect, so you can see that utmost reverence or respect, utmost reverence to the forms and values enshrined in the constitution. How do we do that? So first, make the people aware about the values of the constitution, and then slowly and gradually try to induce this consciousness as to how these values of justice, equality, liberty, fraternity are important. I am talking about only the main values. Number one. Number two is that Ambedkar said that we have created enough dispute resolution mechanisms within the constitution which we are sure that eventually would end up providing justice to all the elements of society. If some of the legal rights are being violated, we have created intensive judicial architecture. You can go to the district court and get your disputes resolved. You can go to high courts. And if some of your fundamental rights are being violated, you can knock on the doors of Supreme Court. That is only when your individual rights, let's say, are being violated. But enough number of mechanisms are created to get other kinds of dispute resolved. But Ambedkar understood it will take a lot of time. And because it will take a lot of time, people might get impatient. And if people might get impatient, they might, as a part of training, they might resort to non-cooperation. They might resort to civil disobedience, because they have been trained as such as a part of India's nationalist movement by Congress, by Gandhi. And so he said that what we see, why constitutions fail, is that the impatience of the people immediately leads them to believe that on 26th of January 1950 we are promulgating a new constitution. On 27th of January we will wake up into an India where all our problems would have vanished. And he understood it's not going to happen. And there is no way you can predict the order in which your grievances will be redressed. All I can say is that it will be addressed, but you will have to be patient until that happens. And you cannot ever violate the rule of law just because you believe that your disputes are not being resolved. So because the enough dispute resolution mechanisms have been provided in the constitution, we have enough number of legal mechanisms. You will have to just show patience, because if people do not show patience, that's when the constitutional morality breaks down, and then neither the constitution nor the constitutionalism has any value. And third, and a very important ingredient of or determinant of constitutional morality in a society was hero worship. He was extremely concerned and moved by the tendency of political leaders to fall prey to this trend of charismatic leaders. And his research had told him that as and when there will emerge a political leader who will claim to be singularly representing the will of the people, who will say that I am the voice of the nation, that's when people allow the voice of the nation, that leader, to break down the constitution. And so that person becomes the location of the sovereignty rather than location of the sovereignty being in the constitution. And so he says that we should kill the tendency of the political leaders to act like heroes who will provide all the solutions. The solutions will come from law, the solutions will come from constitution, not from a single person, not from a single charismatic leader of the society or of the people. And look at how true he was. He said that whenever people will fall prey to a charismatic leader, none of the mechanisms of limited government or codified constitution will be effective. This speech was made in 1948, and look at what happened around 30 years down the line in 1975 to 1977. You had a person of the stature of Indira Gandhi, democratically elected person, violates all the principles of democracy and molds the same constitution with same constitutionalism to create an authoritarian government, unilateral government, a government or a state deprived of any right of its citizens. The constitution was not amended to take away fundamental rights. The constitution was not amended to deprive India of its federal structure. But none of these mechanisms meant anything when the national emergency was invoked, and people facilitated that transformation initially because of hero worship. So you can see how far-sighted this person was. And that's when the courts in last 5 years have increasingly started making references to constitutional morality. What is constitutional morality? The laws should be governed by the values, the larger principles of the constitution. And so courts have now increasingly started paying obedience to this principle. Let's see how the constitution provides for these. So I hope you understand this. Carefully drafted rules and procedures were insufficient to ensure the longevity of the constitution. I have already explained that. It required the installation of constitutional morality among the people. People should be moved by the values of the constitution, not by values or norms of the society. It is perfectly possible to pervert the constitution without changing its form by merely changing the form of the administration and to make it inconsistent and in fact opposed to the spirit of the constitution. So you can see you will have this document in the description where you can download and see. I have already discussed this. Now if you are wondering, can there be any basis of the constitutional morality within the constitutional text, then I'm not sure if you are able to read this. Let me zoom it in so that you can read this. I hope it could be clear now. If you look at Article 25, which talks about freedom of conscience, free profession, practice and propagation of religion, this particular clause 1 starts with restrictions subject to public order, morality and health, and to other provisions of this part. All persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. So you can see that your right to conscience, to frame your own transcendent, is subject to morality. Is it subject to social morality? Obviously not. How can it be subject to social morality? Because we understand social morality itself is laden with medieval ideas. If you want to pave the way for modern society, the restrictions on your religion will not come from your social morality, they will come from constitutional morality. Similarly, the freedom to manage religious affairs in terms of denominational freedom, subject to public order, morality. So what is this morality? Supreme Court has clearly articulated the reference to morality in the constitutional text is reference to constitutional morality. This is Article 19 Clause 2, which provides for reasonable restrictions on right to freedom of speech and expression. So let's quickly read and see where can we locate morality. So you can see that nothing in this clause A of clause 1 shall affect the operation of any existing law. So if there is a British law which restricts the freedom of speech and expression, or the new parliament and the new government of state and union, they are not prevented from making any law in so as far as the law imposes reasonable restrictions on the exercise of right conferred by the said subclause, which is freedom of speech and expression, obviously in the interest of sovereignty and integrity of India, the security of the state, friendly relation with foreign states, public order, decency and morality. Which morality are we talking about? We are talking about morality that is rooted in the constitution and not the morality harbored by a family, created by society, perpetuated by religion. We are not talking about those moralities. We are talking about constitutional morality. Now, if you're wondering as to how the Supreme Court has used these sort of values in its interpretation of the constitutional text, for that, let's read the prominent decisions given in last 5 years, and especially the radical decisions, and how they have referred to this basic structure 2.0 to basically reflect the importance of this. In Navtej Singh Johar versus Union of India, the landmark judgment which decriminalized section 377, and it was a huge relief for LGBTQ community. These are exact sentences taken from the judgments. Applying the doctrine, the judges found that the court must not be remotely guided by majoritarian view. What is majoritarian view? Societal view. This is nothing but social morality or popular perception. What is the popular perception? Being gay and lesbian is a choice. It is a depravity of the mind. It is a perversion. That is what society thinks. But they must be guided by the constitutional morality. The courts differentiated between public and constitutional morality and said that the idea of justice always have an overriding effect, that is, constitutional morality has an overriding effect on public morality. We will not consider what people think about gender choices or intercourse choices. We will be moved by the constitutional values. What are the constitutional values? Article 21 provides for privacy. Article 14 provides for reasonable classification. Depriving people from the pleasure of consensual intercourse is a violation of justice, and that's why this judgment decriminalized homosexuality. Then the next landmark judgment, Joseph Shine versus Union of India. Now this was the case where adultery was decriminalized. extramarital affair earlier of a married woman with a third person outside of the marriage became a criminal offense, was a criminal offense in our country, which could have led to the penalty of imprisonment to the third person. Now, this is a social morality which considers women as the property of the man to whom she is married. And just like I cannot snatch away property of another person, that is an offense, that is a criminal offense. You cannot snatch away a married woman from her husband, and that becomes a theft basis for criminal. This idea is rooted in society, which deprives women of autonomy. And that's when you can see the idea of husband as a master of women or a woman as the possession of her spouse was held to be completely contrary to the spirit of the constitution and ideals. Here, doctrine comes as a counterpoise to public morality. So you can understand how these values and what the impact is. And so similarly, Government of NCD of Delhi versus Union of India and India Young Lawyers Association versus the State of Kerala became the other two judgments which actually can be considered as landmark references to the idea of constitutional morality. So I hope with this discussion, largely the idea is clear, why it is important is clear, why is it needed is also clear. So let's now move on to the next news, which talks about Panchayati Raj in distress. Panchayati Raj in distress. Now, the context is that we have 75 years of adoption of the Constitution of India and over 32 years of the enactment of 73rd Constitutional Amendment, which provided for rural self-government and local government in our country. It is going through a phase of decline. Why is it going through a phase of decline? Because the idea that was anticipated, which is mentioned in the Constitution as well, to give them enough power and enough finances so that they can become a unit of self-government, self-sustainable governance, has still not been realized in our country. Obviously, it is directly mentioned in the Constitution, unlike the previous discussion where devolution of powers as well as the finances up to the local level. So you have to give power to the local level, which is what the Constitution expects. But that is something that has not been facilitated by most of the governments across the country. In 2018, there was a question, assess the importance of panchayat system in India as a part of local governments. You have to present an assessment as the first demand of the question. So this becomes number one. Apart from government grants, what sources of the panchayats can look out for financing the development projects? Number two, which basically apart from the government grants, so you have the taxation, there are certain powers of taxation, but now that has been limited by GST, but then you also have the option of borrowing, and then you also have option of charging fee for the services that the local governments provide. This has already been discussed in previous focus videos. So in this discussion, we are not going to discuss finances. Very briefly, we are going to mention it. The strength, sustenance of local institutions in India has shifted from their formative phase of functions, functionaries and funds to the contemporary stage of functionality. How to make them functional? So the problem of fund remains, the problem of functions remain, the problem of finances remain, but now the main concern is how to make them functional. Highlight the critical challenges faced by the local institution in terms of their functionality in recent times. So let's start the discussion as to first understand why, in fact, there was a need to introduce the local self-government in our country. So obviously, we are a country of Gandhi, and decentralization of power was one of the core concerns of Gandhi. He envisioned a stateless society where power and authority will lie in village republics. So that is number one. In that sense, you can call Gandhi as an anarchist as well. So that is number one. But just not Gandhi. Slowly and gradually, in fact, the entire political systems across the globe, started realizing the demerits or ill effects of concentration of state authority at the central level. And that's when the idea of multi-level governance emerged. So the creation of supranational intergovernmental organization is also the part of the same trend. Some problems cannot be taken care of by the national governments, and so you need a collaborative effort of all the governments to take care of problems like terrorism, nuclear proliferation, climate change and global warming. So it is a part of the same trend which made people realize that collaborative effort has to be ensured. But at the same time, there are certain problems, there are certain matters of governance which cannot be taken care of by the state, either acting as a central level or even by the regional governments. And that's when you need local governments. And the states which initially adopted local government, they started realizing the good impact on the governance and the in general rise in the development as well as the living standard of people. That's when the focus really shifted in modern times to the relevance of local government. How local government, when the authority is exercised very close to people, how it ends up doing a better job than as opposed to a situation where authority is concentrated regionally at a regional government level or at a larger level at a national level, is because local government by default is situated among the people. So the authority is exercised right from where the people reside. So if you have a sarpanch resides among the villagers who are the part of his electorate, as opposed to prime minister or as opposed to the chief minister. So when the authority is exercised at a distance, when the authority is exercised from far away distance, it lacks accountability. So you can see, because the power is exercised right away from within the people, it has an extremely high element of accountability or answerability. Also, in terms of local government, it generally involves the participation of the local people in the delivery of goods and services. And now, because people themselves become the part of the process, they have extremely higher level of participation in the governance, and this higher level of participation is what distinguishes the representative, regional as well as national government from the local government. Because of this high level of participation, high level of enthusiasm, and so it adds another level of scrutiny, because now people are directly involved as a part of. So people participation generally increases, it boosts the people awareness. It also, when people are involved in a process, so for example, in terms of a decision taken by Gram Sabha, now Gram Sabha is the entire electorate. So in that sense, if Gram Sabha is really empowered and if it passes a resolution, it will have an involvement of everyone, all those who came on that particular day for voting. And so the governance, when it is exercised at this level, has higher legitimacy, it has higher rightfulness, because the entire electorate is involved in the governance process. So these are some of the very brief reasons that I'm talking about, just to give you a context or an idea as to why local government is so glamorized, because it really has a lot of good things to offer. So all these factors went into formation of multiple committees, which I hope you have read, in Lakshmikant, Balwant Rai Mehta committee, multiple Ashok Mehta committee, and eventually through 73rd constitutional amendment, we added a part 9 to make sure that every state provides for rural local government. It became mandatory after 73rd constitutional amendment for every state, through a law passed by the state legislature, to institutionalize 3-tier local government at the village level, at an intermediate level, and at a district level. And also it carries various mechanisms to provide for political justice. So reservation was provided, not just in terms of membership to SC, ST and women, but also in terms of the positions that were reserved as a part of chairpersonship. So all those provisions that I'm not going to talk about here. What I'm going to talk about here is what are the problems because of which this revolution has become stagnant, or some people would like to believe that it is in the decline phase. Why is it in the decline phase? So in order to answer that question, let's now move on to the next slide, where I have categorized all the issues. So you can see that yes, it boosts the participation, it has greater responsiveness because it is located from among the people, it increases the legitimacy, and obviously people have much higher liberty. Now, lack of political will to implement the letter and spirit of the constitution can be taken up as the summary of the problem. Because when we created part 9, we enforced a skeleton on every state. The skeleton in the form of the structure of the local governance. So we said that every state should have a Gram Sabha. We said every state should have a village level governance, intermediate level governance and district level governance. This is a skeleton. But what will be exactly the powers that will be exercised by each of these levels was left to the discretion of each and every specific state legislature. So only if the state legislature decides to really empower the local level, only then they would be empowered. And now you can understand that empowerment of local government would directly impinge or reduce the authority of the state government. So there is a direct conflict of interest. No chief minister would want to reduce his or her own authority by giving more powers to the local government. And that is the fundamental problem, lack of political will to implement the letter and the spirit. The spirit was to endow the local governments with sufficient power to make them units of self-government. But what we see in reality, that has not been done. So what is the problem? The first problem is that this rural social environment continues to be moved by patriarchy, feudal mindset and caste system. So even if you provide reservation to the women, it is the husband of the women, highlighted by the web series Panchayat, who will continue to have power. So while the authority is with the women sarpanch, it is the sarpanch pati which has the real power. If you reserve a particular seat for an SC person, then not any common SC person will become the sarpanch. It is the close associate of the powerful upper caste person who is more likely to become. And so you can see that procedurally you have provided the reservation, but substantially the empowerment is missing because of the social environment, which violates the spirit of the constitution. Similarly, there is a poor delegation of the 3 Fs, which is funds, functions and functionaries, because the authority lies with the legislative assemblies. It is up to the states to determine which kind of power and to what extent they will be exercised by these rural bodies. When they passed their laws, they did not equip the local government with enough powers. At the same time, there is a huge bureaucratic resistance in terms of collector Raj. Now imagine, if you go and look at 11th schedule, the items that are expected to be delegated to the local level, most of the items listed in 11th schedule are also the matters that are delivered through bureaucracy, the steel frame of our country, a legacy of the British Raj, to be governed through one king of every district. Now, the empowerment of rural and urban local government correlates directly with the reduction in the power of the bureaucracy. And so bureaucracy has become the biggest roadblock in the way of these reforms. At the same time, if you look at these items, for each of these items, you have specific parallel bodies to take care of these concerns. So where water supply can be found in 11th schedule, primary education can be found in 11th and 12th schedule, primary healthcare facility can be found in 11th and 12th schedule, you have specific government departments also supplying to be controlled by directly the state headquarters. The real delegation of power to these bodies would correlate again with the loss of authority by these parallel bodies, and that's when the state governments do not want it to happen, because by controlling these parallel bodies for delivery of services to the citizens, the political parties exercise power. But when everything will be delegated to the direct democracy, when everything will be delegated to the lowest level of democracy, to the third tier, Panchayati Raj, then what will you be able to do? You will not be able to do much when you acquire power in a particular state, and that has become the problem. To the extent that there was a committee formed by the government, Manishankar Iyer committee, which said that if I have to give one summary of the Panchayati Raj, instead of decentralizing power, it has decentralized the corruption. That's the only thing that has happened. So instead of corruption happening at the national or at the state level, now in most of the welfare schemes, the corruption has been decentralized, because now you have multiple decision makers. That's the only thing that has happened. And so state is increasing its control. There is not so much focus on capacity building. The Gram Sabha have not really been empowered, except for in areas where the schedule, which are notified scheduled areas under 5th schedule, except for those areas, there is not much movement. And at the same time, the personal funds in the form of MP and MLA LAD that is given to the MPs and MLAs to be distributed to get some work done directly interferes with the function of the local government. And so that's why, if you look at the suggestions, these are the suggestions that are often recommended to reform the local government. The mention of the word may, which ultimately gives the discretionary power, to the state legislative assemblies to delegate functions to the local self-government, should be replaced with shall. What is the difference between may and shall? May gives you an option to may not, whereas shall as a word does not gives you an option shall not. So wherever there is a mention of the word shall in law, it becomes mandatory. There shall be a president of India. So now for India, there is no other option but to always have a president. There shall be a council of ministers headed by the prime minister to aid and advise the president. Now there is no option. There should always be a council of ministers. So Article 243G, which talks about which powers should be given, it says that the state legislature may by law delegate the powers mentioned in 11th schedule. Now because it is may, they have chosen another interpretation of may, which is may not. Now in this particular case, oftentimes people say that local government is a matter of the state list under the 7th schedule. By amending the constitution and replacing may with shall might violate federalism. But remember, in order for this to be done, you would also require the constitutional amendment. And when you will transition from the word may to shall, you will also have to remove local government from the list 2, which would require not just 2/3 and half of the parliament from both the houses, you would also require approval from half of the legislative assemblies. So only when the state would concur, only when the state would agree, that this change can happen. Also, the second ARC recommends that when we created federalism, we had at the central level 2 assemblies known by House of the People and Council of State in the form of Rajya Sabha. Now, Rajya Sabha is the linking institution in a federal structure. It is a linking institution because it provides the link so that the state or the stakeholders can be represented at the central level. But when we were going for the third tier, we created an extremely decoupled and isolated third tier, not giving it a constitutionally guaranteed representation at the state level. So what the second ARC has said is that create legislative councils for every state and make legislative council as the representative of the local government, just like Rajya Sabha or Council of State is the representation of the states at the center. So in that way, you can take care of the interest of the Panchayati Raj and urban local government at the level as well. Also, the way the State Election Commission, a constitutional authority, every state has State Election Commission as well as State Finance Commission, which is different from Election Commission of India and the Central Finance Commission constituted under Article 280. Now, just like you need an independent, constitutionally guaranteed independent body to provide level playing field to everyone at the election to MP and MLA, you similarly need a body, and so it is the part 9 which provides for this mechanism. But appointment process continues to be by the governor, and governor works on the aid and advice of Council of Ministers. So what the second ARC says is that you should change the process by amending the constitution, appointment by CM, collegium consisting of speaker, CM and the leader of opposition. So you can see by doing that, you can make sure that the person who is appointed as a state election commissioner is not a partial or a biased person. At the same time, we have to focus upon capacity building of PRI personnel, the staff that is provided in their help and support. And so for that, it recommends the creation of Indian Council for Social Science. At the same time, the government to draft framework law on principles of subsidiarity. What is principle of subsidiarity? Any function or any item of governance can be delivered by various levels. But what is the best level from which it should be delivered? For example, if I give you a matter of governance, let's say defense. So you understand that defense of India is best administered from the central level, and that's why it's a part of list 1. But there are various matters in our country that are misdelegated to different places, especially when it comes to the local government. A very simple example, for example, can be health. Now, primary health is best delivered at which level? At a central level, or at a state level, or at a local government level? At a local government level. What the second ARC expects the central government to do is to create a map of activity. All the activities of the government should be first analyzed, and the lowest level from which it can be administered, it should be reallocated to that level by clear articulation. So you can see that subsidiarity, the lowest level from which a particular matter of governance can be administered, should be delegated to that level. So this is called subsidiarity. At the same time, the local Panchayati Raj should be moved by decentralization. But what kind of decentralization? Democratic decentralization. Another problem that the local self-government faces is there is no delineation of functions. If let's say there are n number of items that are mentioned in 11th schedule, we still do not have any clarity which one of them will be delivered by village level, intermediate level or district level. This delineation is missing, which creates confusion. That should be done. At the same time, the devolution should be in real terms, which means may and shall. Convergence. Now convergence is very simple. You should not operate in silos. There should be a regional as well as vertical convergence while delivering goods and services. So you can see that these are the principles of good governance. Citizen centricity should be at the core of delivery. At the same time, because of the problems of MP-MLA lads, we should get rid of MP-MLA lads because it directly conflicts with the duty. Awareness through folk art, media, street plays. There should be an independent arbiter, so that talks about local body ombudsman, so that the grievance of local bodies can be redressed at these levels. So right now we face the problem of the State Finance Commission, their recommendations are delayed, their recommendations are not tabled in state legislative assemblies, and at the same time, the state government do not follow their orders. So make their recommendation binding and create a culture, just like at the central level. Most of the recommendation made by the Central Finance Commission is followed by the central government. That is not the case at state level, which directly restricts the financial sustainability or viability of the local government. By following these measures, we can really bring or move the Panchayati Raj from the state of stagnancy or from the state of decline. So I hope with this discussion, you must be having a better idea about and let's now move on to the next article, which is the SC stays Lokpal. Supreme Court stays Lokpal order of initiating an investigation, allegation of corruption and treating High Court judges as public authorities or public officials under the definition of Lokpal Act. While the judges of the High Court are defined as public functionaries under Anti-Corruption Prevention of Corruption Act, but the Supreme Court has said that High Court judges are constitutional functionaries and not statutory or public authorities for the purpose of Lokpal bill or for the purpose of Lokpal, and so it has stayed the order given by the Lokpal. So the Supreme Court has stayed Lokpal order bringing High Court judges under its jurisdiction, terming the Lokpal order impacted the independence of the judiciary. So we have created various mechanisms to ensure the free independent functioning of judiciary, and so it breaches that fundamental law. And previously we have seen even the Vice President of India has said that the only authority to remove the High Court or a Supreme Court judge is the order of the Parliament and then the order by the President. Now why we are covering Lokpal is because this news gives us an opportunity to prepare a very important statutory body as a part of the GS paper 2 syllabus, Lokpal, or Anti-Corruption Ombudsman created in India. For a very long time, the problem that India was facing is corruption by public officials, by politicians, and by bureaucrats, Group A, Group B, Group C, Group D. Now, why is this a problem? The problem is because of the direct conflict of interest between the investigating authorities, the investigating agencies, and people in power. People in power do corruption, and it's the same people who control the investigating agencies as well. Central Vigilance Commission, Central Bureau of Investigation is controlled by the central government, and if there is an allegation of corruption against the central government, for example, can we expect the outcome to be neutral, and can we expect the investigating agencies to carry out their task with their independent mind? Obviously it is not possible, and so India Against the Corruption movement led by Anna Hazare eventually forced the government to table this Lokpal and Lokayukta Act 2013, which created Lokpal for the entire India for taking up the matters of corruption against the central government employees, and Lokayukta in each state similarly respectively for state government employees. So it has been in existence. So let's quickly go through some of the basic provisions and try to see. The need was that there was a lack of independence, and at the same time it was devoid of transparency. Some like CBI were very powerful, but Anti-Corruption Bureau of the states are extremely powerless. So we needed a strong independent prosecution mechanism. So we created a Lokpal. Now how Lokpal has been created will make it very clear as to how powerful Lokpal can be if it wants to. For example, the independence of Lokpal is ensured through various mechanisms. Appointment process. Lokpal is not appointed by the Prime Minister or the Council of Ministers. It is appointed by a collegium consisting of 5 members, where Prime Minister, Speaker, the Leader of Opposition in Lok Sabha, and Chief Justice, and one eminent jurist selected by the rest of the people become the part. So you can see appointment of, at least in the process of appointment of Lokpal, we cannot expect any partiality. That is number one. At the same time, the expenses of the Lokpal are expenses charged on the Consolidated Fund of India, which means that they do not become the votable part of the budget. Inquiry and prosecution wing has been decoupled, which has been the fundamental problem with the investigating agencies in India. Investigation is after the case has been reported, after an FIR has been filed, the investigation is something that follows to identify the veracity of the first information report. Then a charge sheet is filed, and then the prosecution within the court, the trial begins. These two should ideally be decoupled, because if investigation as well as prosecution is under the same group of people, you can just impact the investigation and then prosecution will have no meaning. That's why the Lokpal has two different verticals. One is called investigation and another one is called prosecution. Salary allowances and other condition of services are laid down, and so they cannot be changed in opposition to the currently sitting members of Lokpal. At the same time, for most of the functions of Prime Minister has now come under the jurisdiction of Lokpal, but there is a strict rule that has to be followed. No complaint against the Prime Minister can lead to automatic investigation. There is a threshold voting within the Lokpal, only then the case can be initiated against the Prime Minister. But except for Prime Minister, it can take up case against any. So you can see that members of Parliament, ministers, Group A, Group B, Group C, Group D officers and officials of the central government. Also, the Lokpal and Lokayukt Act has amended various other provisions, pre-existing legal as well as executive provision. It has changed CBI, it has changed CBC, which basically means that for all those cases in which Lokpal, which are under Lokpal, any of the investigating agencies will take directions from Lokpal. And Lokpal itself has been created to be extremely independent. So the benefit is that its jurisdiction is extremely wide, because if it includes Prime Minister, then you can understand. It has led to the citizens' empowerment, because anyone can file a case and lodge a complaint with Lokpal, and that is the empowerment. Also, it has extraterritorial jurisdiction. It has very clear timelines as to when the investigation should be done, when the prosecution should be done. And so it also provides immunity against false complaints, because if the complaint is proven to be false, the complainant can be penalized. However, we see a lot of challenges with Lokpal as well. We have not seen any prominent public official penalized by the Lokpal in past 6 to 7 years. So it initially took 6 years for the Modi government to appoint a Lokpal, and then we have not seen prominent people. So you can see that delays in appointment have been a cause of concern for Lokpal. It does not have so motu powers to take cognizance of matter on its own. So unless and until people reach out and complain to Lokpal, Lokpal is devoid of its automatic power to take notice of a corruption scandal. There is also a 7-year sunset clause, which means that if I am filing a complaint that I feel corruption has taken place in 2025, the basis of my complaint cannot go before 2018. That is called 7-year sunset clause. So all the complaint should be rooted in the information, or the scandal should not have taken 7 years going backwards. And now you can see the fundamental problem. It usually takes around 5 years for the corruption scandal to come into limelight or to become public. In many cases, the corruption scandals are they come under the public eye after multiple years of hard work by the right to information activists, social activists, and this clause takes away huge number of corruption cases which might be revealed 10 years or 15 years down the line. It also provides penalty against the false complaint. Now there is no understanding as to when you will rate a false or a right complaint, and that deters people from going to the Lokpal under the inhibition that if eventually my complaint is proven to be false, then the action can be initiated against me. Obviously, India does not have a whistleblower protection regime. The bill was tabled once, then it expired. So in India, people who blow the whistle, people who are maybe a part of the system, there is no mechanism to protect them, and that is something that prevents the Lokpal to be able to fulfill the aspirations for which it was created. So these are the changes that have been made by the Lokpal Act. It has changed the FCRA jurisdiction, Anyone receiving more than 10 lakh of fund comes under FCRA. Then it has strengthened the CBI. It has Directorate of Prosecution, Funding Provision and Advocate panel has to be appointed independent of government lawyers. Similarly, the appointment process of CBI director has been changed. Now the appointment will be done through a high-powered committee headed by the Prime Minister. It has enhanced the ambit. So there are multiple changes that the Lokpal Act has brought. You can find this PDF. You can go and read on the IAS Compass website about the changes, but these are not very important. The previous slide was more important. If you remember this, you can answer any question in prelims as well as in mains examination. This is the second last news for today, new approach towards remission. So Supreme Court has ordered and has mandated the states to come up with a new remission policy immediately. Now, what is remission? If you read Article 72 or Article 161, you are likely to find the word where we talk about the powers of the president or governors to grant pardons. So it is a legal power to reduce or shorten the period of a sentence that a convicted person must serve. When a person is convicted, is held guilty, then a term of punishment is awarded, 5 years, 7 years, 10 years, life imprisonment, 14 years. But as the person goes to the jail, slowly and gradually, depending upon the crime that person has committed, or also depending upon the behavior that the person has exhibited, if there is a scope of reformation, then the person should be released early, as opposed to the term granted by the judiciary. And so you can see this is a state power. The provision exists in the Constitution Article 72 and Article 161. At the same time, Bharatiya Nyaya Suraksha Samhita, the procedure code, the criminal procedure code also provide under section 473 and 475 mechanisms of remission. Now, so far, whether a person will get remission or not, that request have to be initiated by the prisoner himself or herself. The state cannot suo motu give remission unless and until the application is specifically made by or on behalf of the prisoner. But now the Supreme Court directives have changed this. They have asked every state to create an exhaustive remission policy, and condition for remission must be given and they must be reasonable. Now you can see that we are moving from the prisoner-led remission policy to the state-led remission policy, where the remission will be an eventual automatic outcome of good behavior within the jail. Why is it important? Its implication is that we have heard many times that the prisons are overcrowded. So we need to depopulate the prisons so that the minimal human rights of the prisoners can be protected. And so if all the states come up with automatic remission policy, people can get out of the jail earlier, and that's what is going to create good living conditions within the prisons. This is a transformation from judicial restraint, where earlier judiciary would be very tough in remission, to now it has adopted a proactive approach. And also, rather than retributive element of justice, it focuses on rehabilitative element of justice. Can we reform the person, and can we later on rehabilitate the person? So it is not the person who could be criminal, it is the condition or the context in which he has become the criminal. So by releasing the person, there is a scope of reformation. But the problem is that the existing strong rules of remission have also been violated because of political pressure. So we see powerful, prominent people in the society going to jail, but frequently being released on parole or furlough. And so if that is the case, remission can also be misused. And so we have to at the same time evaluate the public safety risks of letting the criminals out of the jail in less than the sentence that was actually granted. So this is the last news for today. Can an MP lose his seat? And why it has come into news is because of an MP from Punjab, Amrit Pal Singh. MP from Punjab has approached the Punjab and Haryana High Court to seek permission to attend the ongoing parliamentary session to avoid losing his membership due to prolonged absence. And yes, it is a constitutional provision, Article 101, headed as vacation of seats, which means the seat will become vacant under certain conditions. What are those conditions? Let's quickly see it. No person shall be a member of both houses of parliament, and provision shall be made by the parliament by law for the vacation by a person who is chosen a member of both houses of. It can happen that a person contests Rajya Sabha seat, and at the same time there are Lok Sabha elections contest that seat, becomes both MPs. Now you cannot be MP of both. So you will have to let one seat go. The laws have been made by the parliament in this regard. You can read Lakshmikant to see it. At the same time, you can see that no person shall be a member of both parliament as well as the house of legislature. And if a person is so chosen a member of both parliament and house of legislature, then at the expiration of such period as may be specified in rules made by the president, that person's seat in parliament shall become vacant. So when it is a contest between being an MP or an MLA, automatically your MP membership, your membership of parliament will be void. But if a member of either house of parliament becomes subject to any disqualification, then the seat will become vacant. Or if resigns his seat by writing under his seat, then it will become vacant. But at the same time, you can see that there is a provision because of which Amritpal Singh can be disqualified, is because of if for a period of 60 days a member of either house of parliament is without permission of the house absent from the meeting thereof, the house may declare his seat to be vacant. Now, how will you compute these 60 days? In computing these 60 days, you are not going to consider the time in which the house was prorogued or is adjourned for more than 4 consecutive days, which basically practically translates to 60 business days. So 60 business days of the parliament, if a person continuously skips, then he can be disqualified and his seat might become vacant. Very important from the perspective of prelims examination. So that's it for today. Stay tuned on our Telegram channel, on our YouTube channel for more such updates. Take care.